Thank you to the Commission, to my esteemed co-panelists. I am honored to be in conversation with you today. I want to begin by acknowledging the people forcibly kidnapped and sold from Africa who were enslaved on these lands. From this colony's founding in 1634 until 1864, when the state of Maryland abolished slavery, enslaved Africans were exploited and did work on this land, enabling us to live as we do today. I want to note that I am also an affiliate faculty member of the Gibson Banks Center for Race and the Law at the University of Maryland School of Law. I am an international scholar, and my areas of expertise include international human rights, public international law, racial justice, and transitional justice. And I want to begin actually by thinking about my own positionality as I come to this. White supremacists working with the American Colonization Society assisted formerly enslaved people to establish a colony called Liberia in West Africa. In March 1825 and 1829, Julia Ann Richardson and John T. Richardson, both aged 34, arrived in Monrovia, Liberia. Though the archives do not say the reason they departed the United States, this country's brutal racial violence and terror must have informed their decision to flee. My mother is their descendant, and I am my mother's daughter. I am also my father's daughter. He is from a large ethnic group in West Africa. You likely have heard of the Mandingos. You've also likely heard of the Mandingo black buck trope, which auctioneers used and enslavers used, promoting the purported strength and breeding ability of this group and their agility, which required enslavement, supposedly. Following enslavement, lynchings on this group were required, supposedly, to contend with the purportedly animalistic and brutish tendencies of this group. Headlines across this nation talk about the frenzies of arrest and attempted lynchings and murders of purportedly Black brutes. And so I bring up this personal history to illustrate how, for African descendant peoples, the specter of racial terror lynchings is not past, it is present. From the hanging of laborer David Thomas in 1854 to the hanging and mutilation of field worker George Armwood in 1933, Maryland played host to at least 44 documented lynchings, according to the Equal Justice Initiative in Bowie State. And in listening to the invocation today, I was struck by the names of the unknown. August 1868, an unknown Black man was lynched in Harford County. The victim was murdered for unknown reasons. The only reference to his death is mentioned in a newspaper account of other lynchings. December 6, 1931, an unknown Black man was lynched in Salisbury, Wimmako County, age about 35. This unknown man was dressed in a brown khaki shirt and blood-soaked overalls. Damage to his face left him unrecognizable. Police found bacon and a half of a ham wrapped in a brown paper bag nearby, suggesting that he was on the way home from the grocery store when he was attacked. You were not unknown to your loved ones and those that knew you. We call you in and we recognize our unnamed ancestors and our named ones of racial terror lynchings. We know that there are more unnamed ancestors whose names, whose lives and histories do not appear in the newspapers, but who nonetheless face racial terror lynchings directly or indirectly. This gratuitous violence against Black peoples endures with police murders and vigilante killings. Historian and sociologist Orlando Patterson's work on slavery and social death illuminates a key aspect of enslavement that is marked by open violence. Whether enslaved peoples were subject to that violence or not, the point is that they existed in a regime of structural and open vulnerability. The question is today, does that state of vulnerability persist? How much has it shifted? How much has it morphed? The point of racial terror lynchings was always, and today, is to convey to Black peoples that our lives do not matter, that we are expendable, and that we are disposable. We routinely have the talk with our children, thinking that this will keep them safe, but we know that they and we are subject to anti-Black violence that is irrational, that is not contingent upon our transgression of some law or some norms of respectability. And so it's important that we name anti-Black violence as a persistent legacy of racial terror lynchings. And it's important that we call in Freddie Gray. We are seated here today in Baltimore. This is his home. Freddie Gray lived and died in Baltimore. Gray was known for being fun-loving. He was known for singing and trying to make people to laugh. You likely most know him for his murder, him being killed, subject to a fatal spinal cord injury on April 12, 2015, where he was subjected to a rough ride while in police custody. Gray was treated at the University of Maryland Shock Trauma Center, steps from where I work. He lay in a coma for a week and died on April 19, 2015. Baltimore became ground zero for Black Lives Matter and the racial justice uprising that exploded around this country, and claims for recognition for Black humanity that rebound into the past. And I want to surface the ways in which Black people subjected to racial violence and racial terror have always asserted their right to be free from racial terror and lynchings, irrespective of whether national laws recognize this or international laws recognize this. And it's important because Black peoples and other subordinated peoples did not have the tools of the law to assert their rights claims. That did not mean that they didn't make claims. They did so repeatedly, early on. They resisted, they did so in our speeches, in our literature, and the like. If we think about another Freddie, who is also from Maryland, Frederick Douglass, we know his infamous speech, "What to the slave is the 4th of July." And we know that in this speech, he lambasts the United States for its hypocrisy. He calls out the racial terror. He speaks about the burning of flesh, and he asks whether he's to argue whether this is wrong. And he says, "I'm not going to argue with a system thus marked with blood and stained with pollution as wrong, because I have better employments of my time and of my strength." And he lambasts this nation as being guilty of practices more shocking and bloody than anywhere else on earth. And it's important to raise up these narratives because Black peoples have always been actors, have never been just subjects waiting for saviors, white saviors, to recognize their humanity or to reflect them in the law. Black peoples made explicitly transnational and international claims about their rights. They did so in places like the 1920 Declaration of the Rights of Negro Peoples of the World. Gathered in Harlem, over 25,000 members, stated a number of principles. One of them lambasts the United States again for its history of lynching, of burnings by mobs, and the brutal and inhuman treatment. The articles go on to talk about how this is a barbarous practice, and that is a shame and is a disgrace to this, to any civilization, and that any country guilty of such atrocities should be outside the pale of civilization. Black peoples also, in resolutions by the Pan-African Congresses passed between the 1900s and the 1940s, talked about their rights to equality, their anti-slavery rights, their anti-lynching rights, and their anti-colonial rights. For instance, in 1923, the Third Pan-African Congress held in London again noted the United States' history of lynching and mob violence and how this should be suppressed. And so I illustrate that Black peoples, Black states, Black social movements, Black civil society groups have articulated normative claims to protect themselves from racial terror and lynchings. And they did so irrespective of whether the legal regime recognized this. And that is an important point because there's a way in which those who are in the legal academy can pretend as if the positive law doesn't enforce powerful relations, as if we have always had the levers of power to express our equality in the law, as if the law is not a tool of dispossession and hasn't functioned as that historically. And so when we look to the law, we begin with those who were subordinated under the law, because the law also served as a means of ratifying racial terror and violence and subordination, which we are well aware of. We know that from legal cases like Dred Scott, and we know that because this court told us that the white man has no rights, that, I'm sorry, the black man has no rights. Well, I mean, you know, that slip of tongue is, you know, perhaps, yeah, a Freudian slip there. But yeah, that the black man has no rights, that the white man is bound to respect. We know the quote. So I say that all before invoking the legal framework, because I think it's important that we destabilize the legal framework, because the legal framework in its large part erased Black peoples and our agency. So today, when we talk about international law and we invoke it, we should not sort of ignore the ways in which international law has served to further our own subordination. Even still, international human rights law, particularly after the Second World War, is supposed to have brought in a shift such that instead of just sort of state-to-state claims for reparations, states owe reparations to individuals within the state and individual societies. And so when we think about the basic principles and guidelines on the right to remedy and reparation, which is supposed to be a compilation of international human rights standards. Thankfully, my co-panelist has artfully spelled out the 5 forms of remedy, which are included in there: restitution, compensation, rehabilitation, satisfaction, and guarantees of non-repetition. It should be clear that this commission, in terms of thinking about reparations for racial terror lynchings, needs to look at a comprehensive reparations package that encompasses all of these forms, and that what is needed is much more than sort of governmental social services, because part of reparations is the state's acknowledging of its past history of abuse and ongoing abuses, and then repairing with guarantees of non-repetition in the future, and those guarantees are important. And I think it's important to situate this move for reparations within a broader context of what's happening within the US, but also globally what's happening. And that is for historical reparations. Infamously, the enslaved have had to pay for their own freedom, right? We know about Haiti having to pay reparations to France. Also, in the United States, in 1862, Abraham Lincoln signed the District of Columbia's Compensated Emancipation Act, which in exchange for the freedom of those peoples paid the owners of enslaved peoples, and also offered $100 to formerly enslaved people to repatriate to Africa. And so we should know that the history of reparations has been primarily one in which those who benefited from enslavement were given reparations, and those who, and their descendants who suffered from enslavement did not receive reparation. And so our nation's long history is marked by centuries of non-repair. Following the Civil War, unlike other places who, following a conflict, immediately end up putting into place measures that are aimed at repair and reparations, we have a huge gap in our national and state level efforts. And so we look to, say, 1993, so that's very, very long after the Civil War, where a Florida legislature commissioned a study of the 1923 Rosewood Race Massacre. And report from that led to reparations. Florida was one of the earliest states to provide direct reparations to descendants of the enslaved. The bill provided for merely $150,000 to each of the 9 Rosewood survivors. North Carolina's Greensboro Truth and Reconciliation Commission also was examining a history of racial terror and killings that took place of anti-Klan demonstrators. And that commission in May of 2006 put forward a number of symbolic reparations that it believed the city and others should do. We might be more aware of California's recommendations. In 2020, California became the first state to create a task force to study reparations proposals. Its reparations recommendations have not all been taken up by the state, and this is sort of living history. The city of Evanston in 2021 had a restorative housing program which allowed eligible Black residents $25,000 for housing-related expenses and direct cash payments. And we've also heard reference about the Commission on Police Torture and the reparations that were received then. And so I will be brief because I've been told I have 2 minutes. And what I want to just sum up is that there is this long history of racial terror and violence, and there is also a very long history of not doing anything about that racial terror and violence. And until recently, we see state and local efforts to do this. And I want to situate this against global precedents of reparations for historical violence, which I will include in my written testimony. But Canada has been forced, after a large class action settlement, to give payments to those who are subject to Indian residential schools. And Canada is situated right above us and is not the 51st state. But it is somewhere we can look to for thinking about addressing a history of racial terror. Similarly, New Zealand and Australia have also made efforts to, not complete efforts, but have made efforts to address their own histories of abuse through reparations programs and the like. And so the conclusion that I want to just end with is that the responsibility is a societal one, and we are grateful to Maryland for taking the first step. And I hope that we all here and those watching online will continue to hold Maryland accountable for taking this first step towards repairing a history that is present and that is ongoing and that is situated within a larger global justice context for allowing greater repair and redress for the historical and ongoing harms of racial violence. Thank you. I do want to say something. I think that our conditioning is conditioned, and so for Black people to say things that aren't advancing Black people's liberation is not something that is new. That happened in the past, that happens today. And I think to invoke Toni Morrison, who has written about the master narrative and has helped us to think about how the ideological scripts by people in power function to limit our imagination. And what we can do in this place is to imagine, as our ancestors did, freedom as an actual place, right? So this is Ruth Wilson Gilmore thinking about freedom as a place. June Jordan, another one of our ancestors, wrote about how when our grandmothers were on their knees in the big house, they imagined a home full of family come to freedom. And that they did so, as Marcus was saying, that we could stand up, right? And so in this moment, it is on us to actually stand up to recognize that freedom is a place that is imagined, but is also one that is built and one that has to be demanded, and it is our job in the present to demand that. I mean, I think that it's important to understand white people as raced, and so that race neutral is a term that sort of like basically makes a white baseline the baseline. And so when we invoke, or not we, but when we are responding to terms about neutrality, essentially what we've had in this country for years is affirmative action for white people. And so it's important to actually call that what it is, and that gets called meritocracy, where other groups, women were excluded, Black peoples were excluded, other people were excluded from institutions. That's literally the history of this country. And so there has actually never been a race-neutral operation of institutions or the law. And it's important that we are frank about not only our history, but also our current present. And so it's not Black peoples are racist and nobody else is racist, because that also serves the invisibility of white supremacy and the like, and I think it's important to name those things.